This question reads, to what extent should the issue of costs be spoken to at the conclusion of the trial? Will the judge be open to persuasion in this regard? What are the key criteria, I believe, in determining an appropriate amount? Well, presumably this question is submitted by a student or by counsel because I suppose the greatest flexibility is in that area where we're talking about the counsel fee at trial. Maximum is $300, and also an amount of $30 for preparation of pleadings. And of course, those figures are not available to anyone who is not either a student or counsel. The amount which is awarded to the student is 50% generally. I should think that the key criteria would be probably the quantum of the claim. If the maximum that the court can award is $3,000, is $300, I think you're going to get closer to the maximum award if your claim is approaching the limit of the court's jurisdiction of $3,000. Of course, the other matter which the court will probably consider is the degree of difficulty in the case, the amount of time and preparation, the amount of trial time. But certainly I should think that the subject of cost should be one that the counsel discusses with the judge to enlighten him particularly as to the matters that he will wish to take into consideration. How much time have you spent in preparation and so forth, and whether the matter is of some importance.
Thank you. Ben, would you like to deal with the question?
There are a couple of questions here. I'll just, one of them, if a claim for prejudgment interest is not stated in your claim, can you still obtain it upon default judgment? Now, if you are talking about default judgment signed by the clerk, the answer would be no. If you're talking about a judgment in default at trial, where the judge is at least perhaps hearing the evidence of the plaintiff and considering the matter, the answer would be even if you didn't put it in your claim, you could approach or you could ask the trial judge to consider it. Certainly not at the clerk stage. The clerks would not want to include something of that sort, but the judge may, under the circumstances, in really dealing with the matter as an assessment, may feel that an award of prejudgment interest is appropriate.
Thank you, Ben. One question here is, should a solicitor sue on an unpaid legal account in provincial court or small claims court, or should he tax his account under the Solicitors Act before the taxing officer of the Supreme Court? Not an easy question to answer. Obviously, it's quicker if you go through our court if there's a backlog in the master's office. Some people are bringing their actions in our court because they think they'll get interest prior to the introduction of the act, which permitted solicitors to get interest. I had a case on that, and I decided they were not entitled to interest before the act came into effect. And so that isn't going to make much difference unless some other judge decides differently than I do. Our feeling is, I would think, as follows, and perhaps the other judges might respond. If there is a dispute as to the retainer, then I would think it's proper to go to our court, because the masters do not wish to deal with matters in which there's a dispute as to the retainer. Where you retained, what is the extent of your retainer, etc. Where it's simply a matter of the amount and whether the amount is proper or unfair, then I would think that that is something the master should deal with, because that's their area of expertise. We might, depending on the complexity of the case and how long it'll take, just deal with the issue, for example, of jurisdiction and then send it back to the master. In other words, if we find, I'm sorry, not jurisdiction, but retainer. If we find there was a retainer, we would then send it back to the master. If there's time during the day to deal with it, we might. Does anybody have a different reaction on that?
Well, it's certainly an ongoing problem. We, of course, have all sorts of professional accounts sued in our courts. We don't only have lawyers, and we have architects and accountants and everybody of that sort. And you might say, why is it that we should treat lawyers or legal accounts any different? And my response would be along the lines of Judge Bromstein. Namely, the master is dealing with the question of solicitors' accounts, 6 hours a day. And I can tell you, you only have to be out of practice a couple of years to really lose track of the kind of fees that are fair and reasonable for the work. We hear all the time about the difficulties in connection with the legal aid tariff, and the Attorney General has addressed himself to this recently, again, about the need for changes. And certainly in the area of solicitors' fees, the master is really the man who has his finger on the pulse. I have, I think, on about 2 occasions where I either made a ruling on the question of retainer, or whether the question of retainer was not in dispute, referred the matter to the master. I'm not just sure my right in doing so, but I did so out of a sense that I really felt I was not in a good position to assess, because that's really what you're doing. Now, I know there are all sorts of standards or things that you can set up. You can say, have you got your docket sheets? Is there an accurate description of the services rendered and things of this sort? And I think, speaking personally, that this is probably one of the reasons you get into trouble, or lawyers get into trouble. I remember years ago, at a young lawyers seminar, I think it was Mr. Justice Arnott stating something about he thought it would be nice if lawyers could just send out bills like doctors, to services rendered. And there's going to be so much. And there's been a great deal of discussion about the nonsense or the detail in lawyers' bills, and particularly in estates and things of that sort. But certainly if it comes before our court and the judge is prepared to deal with it, he's got to have something to go on. He's going to have the hours. He's going to have what you consider is a fair hourly rate. The very things, of course, which the master normally deals with. And I think that it's better for the profession, notwithstanding the fact that there may be some delay in the master's office. But I think we are tempted to refer them to the master to see if we can get the benefit of his expertise.
Thank you, Ben. Marvin, we are running into time, but I'm sure that we have time for a few more at least.
This is a question involving pre-trials. Perhaps I should read the whole question first. Why are many requests for pre-trials refused? As the judge reviewing the request only has the pleadings on which to base his decision. Do you not think that most requests, especially from law firms, that's underlined, should be granted? Is there a backlog of pre-trials? I think as a generalization, one would hope that, or wish, if it were conceivably possible, that particularly in this court where you have unrepresented, represented litigants, that every case be pre-tried. Obviously, with 16,000 cases a year, in Metro, I believe up to 3,000, perhaps another 30 or 40,000 up to 1,000, which are, in any event, automatically, they proceed to a referee. It's impossible to have pre-trials in every case. Judges review most of the files, and each judge selects the cases, I think, which in his or her opinion would be most suited to be pre-tried. You've heard this morning the question of how many cases are now taking 1 or 2 days to be heard. Those are the kinds of cases, obviously, that should be pre-tried, because presumably if they take a day after they've been pre-tried, you can imagine how long they would take if they were not pre-tried. I don't think at this present time there is a substantial backlog, but again, it's up to the individual judges as to how they perceive whether a matter will benefit from a pre-trial or not. And there is a related question. If as a result of discussion with the trial coordinator and or a judge in chambers, you expect a pre-trial hearing to be set, or a pre-hearing to be set, and receive instead a date for trial, what should you do? Well, other than scream, I suppose you might want to call the trial coordinator. Trial coordinator has kindly given her phone number in the materials which have been handed out. I can say with some degree of certainty that the phone number to the trial coordinator is not the same phone number to the Toronto Small Claims Court, so you may be able to get through. But certainly if you expected to have a pre-trial hearing notice and you get a notice for trial, invariably, you know, mistakes are made. You've got thousands of documents going through the courts. One is only human, and you know, to err is human, to forgive divine. So simply call the trial coordinator. I'm sure if it's an error or a misunderstanding, that could be straightened out.
Thank you, Judge Zuker. I guess, to be fair to the subsequent speakers, we should cut off the questions at this stage. The fact that there are a number of unanswered questions shows that we should be holding more of these to permit people to deal with other topics. This is only the first time that we've done anything like this, and we can, of course, deal with other questions privately afterwards or personally afterwards, and hopefully we'll only be starting the process of the interaction in relation to this problems of the rules, etc. now. The next person that I'm going to be introducing happens to have a lot of background that some of the rest of us don't have. She is fluent in French. She's a member of the Quebec Bar as well as the Ontario Bar. She's the author of a study on small claims court for the Federal Government Consumer Research Council of Canada called Small Claims Courts and Consumer Access to Justice. In private practice, she was involved with labor law and litigation. She was appointed as a judge of the Provincial Court Civil Division in the last few years, and she's actively involved in the Judges Associations. She contributes to many different judicial activities with considerable gusto, and she does so much that I sometimes wondered why she hadn't got her Doctor of Laws, and her reply was, well, I knew somebody who had that Doctor of Laws, and if anybody doctors the law, he does, so I decided not to. Judge Pamela Sigurdson.
My topic is new trials and appeals. You will also notice that the next speaker's topic is appeals. With respect to new trials, the paper is there. I simply want to underline a couple of things. With an application for new trial, for matters over $500, you must have a transcript, and that transcript must be filed before the date of hearing if you want the judge to read it. This also goes, I suppose, with motions. If you are going to argue law on a motion, it certainly would be nice to see the material before 9:15 the morning of the motion. It's important to note, as I have at some point, the difference between applying for a new trial in Toronto, where you must go before a different judge than the one who heard the trial, and outside of Toronto, where you must appear before the judge who heard the trial. If you are interested in preserving your right to appeal, you should note the materials with respect to making a motion to set aside a default judgment, as opposed to framing your motion as an application for a new trial. The way the divisional court views An appeal may, or whether you go by judicial review, may depend on how you have framed your motion and how you get the judge to endorse the record. With respect to appeals, please make your motion within the 14 days allotted to the Ontario Divisional Court. Please remember there is no stay of the judgment unless you apply for a stay. Please remember that there is a difference between an appeal and an application for judicial review. I didn't. On page 183, thanks to Mr. Justice Krever a little while ago, the Lachowski case in the middle of the page was an application for judicial review and not an appeal. Please remember that in Toronto, it is the amount claimed that is relevant to whether you can appeal, whereas outside of Toronto, it is the sum in dispute. And lastly, I would like to add to my paper, somehow a paragraph got slipped up. In the case of Gelber versus Allstate Insurance, you might want to put this at the bottom of page 183. 1983, 41, Ontario Report 2nd, 318. Our next speaker stated, and it is now, well, you can see from the report, the Divisional Court is without jurisdiction to hear an appeal from an order adjourning a trial prior to its commencement because it is an interlocutory order. In Harrelade versus Bazuk, B-A-Z-U-K, a decision unreported of the Ontario Divisional Court, Mr. Justice Montgomery stated there was no trial before the Small Claims Court. He really meant the Provincial Court Civil Division. An appeal lies to this court only after in a trial the appeal is dismissed. So it's important again to remember whether you're appealing or applying for judicial review. I hope that helps with your time frame, folks, because I'm finished. I now have the great pleasure to introduce Mr. Justice Horace Krever, who taught me evidence in second-year law school 20 years ago. And if I make mistakes in evidentiary rulings, appeal them to him. Mr. Justice Krever has a long 3-pages curriculum vitae, the most important of which is that he is a judge of the Supreme Court of Ontario and often sits in the Divisional Court as a sitting single judge. Throughout his career, both in the bar and on the bench, he has been interested in law relating to mental health and to health in general. He currently is alternate chairman, Advisory Review Board under the Mental Health Act of Ontario. He is a fine and gentle man, and one I am proud to know and proud to have taught me. Mr. Justice Krever. Are you standing? I just about walked off the position.
I had hoped when I was preparing originally for this program to be a little more practical about what you should do and don't do as a matter of advocacy, but I came across some problems that I thought it was important to discuss, and only if I have a little time, which I doubt at the end, will I do what I had hoped to do in the first place. My paper begins at 195, page 195 of these materials, and I want to start by making a correction that's already been referred to by Judge Sigurdson, and it's at page 198. You'll see that the first sentence says, an appeal lies from a small claims court and the provincial court civil division to the divisional court under Section 17 of the Judicature Act and Section 108 of the Small Claims Court Act. With certain exceptions, an appeal may only be taken where the amount in dispute exceeds $500. That's only partly correct, as has just been pointed out. There's a difference. Why there's a difference, I am not sure. That there should be a difference is debatable, but as Judge Sigurdson just pointed out, that's true of cases in the small claims court. For the provincial court civil division, as her paper correctly points out at pages 182 to 183, the appeal lies from a decision of the provincial court civil division only where the amount of the claim exceeds $500. The test is the amount of the claim, not the amount in dispute. It doesn't seem an entirely rational, there may be, and maybe Mr. McCann will tell me privately later, there may be some reason for making that distinction, but the problem arose before me in the divisional court yesterday in a case from the provincial court civil division, a decision of a deputy judge who had a claim before him of $700 and some odd dollars and gave judgment for precisely $500. I wonder why, but that happened to be the basis of the appeal. And the first issue was a preliminary objection to the right of appeal because it was not, the amount was not in excess of $500, but it seemed to me that the governing legislation was the rule that applied to provincial court civil division that talked about the amount of the claim, and the amount of the claim was $700 odd, so that there was a right of appeal. If you look at the Section 108 of the Small Claims Court Act, which deals with the right of appeal, you will find, and I think that's at page 305 of the material, you will find the, is it? Yes. Subject to Section 107, an appeal lies to the divisional court from the decision of a judge at or after a trial or upon an application for a new trial, except in cases where a new trial has been granted. A, in an action where the sum in dispute exceeds $500, exclusive of costs. Now, suppose the judgment that's been given is for $500 and the claim was for $900. Has the defendant a right of appeal? What is the sum in dispute? If it is $500, the amount of the judgment, it does not exceed $500. Is there no right of appeal? If the plaintiff is dissatisfied, because the plaintiff claimed to be entitled to the additional $400, what on the appeal, as opposed to a trial, is the amount in dispute? If it is the difference, $400, is there no right of appeal? That's when you look at the small claims court. If you go to the provincial court civil division, and by the way, the right of appeal is in a strange place. I had always been taught, and always taught, that there is no right of appeal. There is no automatic right of appeal. For an appeal to lie, it must be found in a statute. There's an exception. In the case of the provincial court civil division, the right is found in the rules, in the regulation, not in the statute. That comes about by, if you look at page 239 of the materials, you'll find the language of the current version of the Provincial Court Civil Division Act. And down at the bottom of that page, Section 6, subsection 2, says, except insofar as they are inconsistent with this act or the rules, and I am emphasizing the rules, the Small Claims Court Act and the rules and regulations thereunder apply in the same manner as if the provincial court and the judges and officers thereof, the small claims courts, and judges and officers thereof in the proceedings in the provincial court were proceedings in a small claims court. I understand that to mean that with respect to Section 108 of the Small Claims Court, which we've just looked at, which said where the amount in dispute exceeds $500, that is modified if the rules under the Provincial Court Civil Division Act are inconsistent, and they are inconsistent. If you go to page 255, you'll see that the regulation has in effect modified the section of the Act, because you see under Section 57, we see the following sections of the Small Claims Court as modified hereby apply to proceedings of the court. If you go to the bottom of the page, the very bottom, subject to Section 107, an appeal lies to the Supreme Court, A, in an action or garnishee proceeding where the amount of the claim exceeds $500. So in the Provincial Court Civil Division, one looks apparently at the amount of the claim, and presumably that's the amount asked for in the original proceeding, in the claim. So with respect to the Provincial Court Civil Division, suppose you have an action again for $900, and the defendant appeals from a judgment for $500. The judgment at trial is $500, the defendant appeals. Does he or she have a right of appeal? The amount in dispute does not exceed $500, but the amount of the claim does. It's been held yesterday that there is an appeal. The answer is yes. Suppose, however, that the plaintiff is dissatisfied and says that he or she should have got the additional $400. The amount in dispute is $400, but the amount of the claim was for $900. So there would seem to me to be a right of appeal. And I don't know if that really was the intention, or whether or not the rights of appeal should be the same. With that correction, I think the rest of that part of the paper is correct. But let me turn to another area very briefly, which needs to be corrected, completed is a better word than corrected, and that's the question of costs on appeal, the costs in the divisional court. With your materials, you receive some loose pages, and there are 2 pages called an addendum. It says at the top, 28A, Appeals to the Divisional Court Addendum. That pagination refers to the original typescript that I submitted. For the purposes of the materials you now have, I think you should change the page numbers at the top from 28A to 224A and 224B. And I wish these pages had holes punched in them. They should be inserted right after page 224. And again, there's a difference between the procedure respecting small claims court and a small claims court and the Provincial Court Civil Division. With respect to the small claims court's appeal, we have section 114, and you see the language of the section at the bottom of page 224. It reads, the cost taxable between party and party of and incidental to an appeal are the actual disbursements and no greater amount over and above actual disbursements than $25 inclusive of counsel fee. And the costs of an appeal between solicitor and client are taxable in the county court scale. Now, with respect to the Provincial Court Civil Division, we have a rule. And the rule is found immediately above what I've just read. It's Rule 58 and has 2 sub-rules. And as I read those 2 sub-rules together, with respect to the provincial appeals from the Provincial Court Civil Division, there is something I should perhaps go back a step. if you read subsection 58.1, I've left something out of the paper, and that's why I put in these two additional papers. Let me take you to the language. The costs of an appeal are in the discretion of the appellate court, and on any appeal, the court may allow the same counsel fee as could a trial judge in an action for more than $1,000 pursuant to the tariff of costs. Well, in the original paper, the reader would be puzzled, what are those costs that the trial judge could allow in an action for more than $1,000? And that's found in the tariff of costs, which is a part of the rules, and you'll see it on page 224A, formerly 28A. In the middle of the page, the following costs are to be allowed to a party entitled to costs in respect of the services of a solicitor in actions where the amount claimed exceeds $1,000. The second item is the item counsel fee at trial up to $300. But you'll see in subsection 2 of rule, or subrule 2 of Rule 58, that where the court, that's the divisional court, presumably, it dismisses an appeal and comes to the conclusion that the appeal had no merit and never should have been brought, the court may fix costs against the appellant at up to $500 plus disbursements. So if I'm correct in my understanding of the rule, if you read the rule, both sub-rules together, and the tariff of costs, for appeals in the provincial court civil division to the divisional court, the result is this. If the divisional court dismisses an appeal and is satisfied that the appeal was without merit and should not have been brought, it may fix the costs against the appellant at up to $500 plus disbursements. In any other case, the costs on appeal are discretionary, and the court has the same discretionary as a trial judge in an action before the trial judge for more than $1,000 under the tariff. That is to say, may allow what the trial judge may allow in his or her discretion up to $300. I don't know of a case, and I would be surprised if there exists one, in which the divisional court has held that the costs ought to be taxed at $500 because the appeal was without merit. Many appeals are without merit. And it's hard to tell you when not to appeal, but I discussed this matter with the registrar and with Mr. Justice Reed, who is the person who speaks for the divisional court at meetings of the judges and of the trialist committee, to get their impression of the number of appeals that are successful. And they weren't far off. It's entirely a guess, it's an impression. There's been no statistical analysis made. And the guesses range, and I think they're in the right ballpark, if I can be colloquial. The guesses range from between 25% successful and 40% successful. A lot of appeals should not be brought, nevertheless, the draconian remedy that the court has to fix the cost of $500 is, I think, one which has probably never been exercised, and I think it would have to be a very strong case would have to be made for the exercise of it. But it's there, and who knows? Someday one of the parties may ask that it be exercised, and it may well, in order to deter frivolous appeals that maybe are brought for the purposes of buying time and for no other reason. Now, can I say something about motions and the right of appeal arising out of motions, orders made on motions? And again, I'd like really to address this not only to all of you, but to Mr. McCann, because it seems to me that there is something in need of correction here. That's a very personal view, and I don't want that to be a reflection on any case I am going to refer to. There is a very important distinction as far as the divisional court is concerned, as far as the law is concerned, and as far as knowledgeable lawyers are concerned, between appeals and judicial review. Don't assume from what I'm about to say or from anything you've heard that you have a choice. You can either move for judicial review or you can bring an appeal. The appeal is statutory. Judicial review is really an inherent power of the Supreme Court of Ontario, going back to ancient times. In most cases, it would be the old remedy of certiorari, which always lay to a superior court to oversee a decision made by a court or tribunal that in the language of the law is called an inferior tribunal. That is to say, inferior in the sense that it is answerable to the King's or the Queen's courts, the Supreme Court of Ontario, or the royal courts in the old days. It's jurisdictional in nature. It's not the case that you can, if you're too late with an appeal because you've forgotten what the time limits are, or because the amount doesn't entitle you to an appeal, it's not the case that you have automatically the right to judicial review. Judicial review is jurisdictional only, and the grounds on which a court will review a decision, the divisional court will review and interfere with a court or tribunal on judicial review are very limited. And the court or tribunal in question, generally speaking, has the right to be wrong. Merely because the court comes to the conclusion that it would not have decided the case the same way doesn't mean that it will interfere on judicial review. It might do that, however, on an appeal. Well, let me bring you up to date, because the most recent development in this area occurred 3 days ago, on February the 8th, and this case I'm sure will be reported, and I think it has some implications that ought to be looked into. Let me start with a couple of cases already mentioned by Judge Sigurdson. In the Gelber case that she referred to, and which she gave the citation, a decision this year, reported in 41 Ontario Reports, second series, page 318, the plaintiff responded before the divisional court was unrepresented, and the appellant, the defendant in the Provincial Court Civil Division, was an insurance company. I've forgotten now precisely what the cause of action was, but it was something like this. It was an action by the individual, unrepresented, against the insurance company for damages, I think, to his carpet that was improperly cleaned when there was an insured against loss. And there had been some adjournments, and the case came on before Judge Sigurdson on the day appointed for trial after certain adjournments, and the counsel for the insurance company, the defendant, asked for an adjournment. And this application was opposed by Mr. Gelber, appearing without the benefit of counsel. And the adjournment was granted, but it was granted on terms. And that's another thing that distinguishes the case from the Lachowski case, which I will mention in a minute. It was granted on terms, and the terms were that an immediate payment of a small amount of money, which was, I think, $20, be paid to the plaintiff within a certain number of days, 20 days, I think, and that $800 be paid into court. The insurance company then appealed to the divisional court, and it came on a day when I happened to be sitting as the divisional court, and it was I who raised the question. Counsel got up ready to argue the case, counsel for the insurance company, and again the individual plaintiff was there representing himself and he thought his wife, and I immediately asked counsel where his right to appeal lay, and he wasn't entirely ready for this, but he knew the act, and he said it's section 108. And section 108, as we just seen, says an appeal lies to the divisional court from a decision of the judge at or after trial, or upon an application for a new trial, and that part didn't apply. So it's only a judgment at or after trial that is a judgment that may be appealed if the amount is right. This was a case in which counsel was seeking not to have the trial. He was asking the trial judge to postpone the trial, saying, we don't want to go on today, or we can't go on today, postpone the trial. And the order was made then, all right, I'm granting an adjournment, but these are the terms. Relying on the case of It's Lachowski, Lachowski and the Federated Mutual Insurance Company, which was decided in 1980 and is found in 29 Ontario Reports, second series, page 273. Counsel said that was a case where an order had been made requiring payment, and but it was not, by the way, as a term of the exercise of discretion. It was a payment, I think, into court or a payment to the plaintiff. And on judicial review, arguing that the case was, the order was beyond the jurisdiction of the court because the court had no jurisdiction to make that. There could be found in the legislation no jurisdiction to make that order. Mr. Justice Corey quashed the decision. Counsel said, that's the authority. This is the same kind of case. And I was not persuaded, and if you read the reported judgment of Gelber, you'll see that I said that case has no application to this case because we are dealing here with a right of appeal. That was judicial review. I didn't go on to say, and also it's distinguishable on its facts, but the decision I made was that you can't appeal that kind of an order because it was not made at or after trial. I was asked to give a large and liberal interpretation to the Act, as the Interpretation Act requires me to, and I thought that to do so would be inconsistent with the purposes of the Act, which is speedy and effective justice, and not to encourage interlocutor proceedings and interlocutory appeals. So the case stands for the proposition, to the extent that it's right. I've been told I can't finish the story, but I'm going to. To the extent that it's right, that it has to be at or after trial. Now, last week, and this is an important matter, I think, because I think it may need some looking into. Last week, Mr. Justice Henry in the Divisional Court, in a case called Ron Robinson Limited and the Canadian Indemnity Company, February the 8th, 1984, and I'm sure a case that will be reported, decided a case which I think is an extension of the proposition that I've just given to you. That was a case in which the insurance company was the liability insurance of the insurer of the plaintiff and had settled some claims made against the plaintiff. Then it sued the plaintiff, its insured, for the deductible portion of the claims under the policy, and got judgment. The judgment was for $2,700. Thereafter, after getting judgment, the defendant insurance company was sued by the person from whom it was to collect the judgment, its insured. The insured now suing the insurance company, saying, in the settlement of the claim you were negligent and I want damages of $2,700, the amount of the recovery you just got from me. The matter came before Judge Zuker on a motion, and he held that no action lay because the matter was res judicata, that it was a matter that arose in the original action, could have been inserted in the original action, and it was now decided against the plaintiff and dismissed the action. The plaintiff now appealed to the divisional court, and the question of the application of the decision I've given you, was it at or after trial? It was a motion made before trial. It wasn't at trial. And, but it was a final judgment. It finally disposed of, unlike the case that I told you about, where it was simply an interlocutory order granting an adjournment on terms, this finally disposed of the litigation for certainly an appealable amount, an important question of law, but, said the divisional court, there is no appeal. There is no appeal because of the language of Section 108 at or after the trial. Now, I don't know that a motion that could have been brought at the trial, that's brought before the trial, should deprive the losing side of an opportunity to appeal. And I'm afraid that it might encourage a lot more motions in the Provincial Court Civil Division, or more motions, because rather than have these motions brought at trial, or arguments made at trial, because there's no appeal from it. And I wonder if that is something that needs to be corrected. There is one other thing, one last comment. Everybody has been assuming, I think, for a long time, that there is, of course, a right to bring motions before the Provincial Court Civil Division or the Small Claims Court. And that assumption was also made in this case, but I'm not sure that it's settled. Can I just read you one passage, 2 sentences, and then I will stop. Mr. Justice Henry, at page 4 of his reasons, says this: I have been referred to no provision in the Act or rules which expressly provides for the determination of the issues between the parties in pretrial proceedings such as a motion for judgment. But counsel for the appellant does not take the position that such proceedings are not available under the provisions that I have mentioned. In other words, there is no dispute before me that Judge Zuker had power to make the order that he did. There's no dispute before me that he had the power. I, therefore, do not decide that question. So it may be that it still requires to be decided, but I ask you to think about that case and see if the implication that I suggested exists do exist. Thank you.
Thank you, Your Lordship. I don't like to cut off someone, particularly someone I may have to answer to in an appeal, but it may be that that just shows the importance of the things that Mr. Justice Krever has to deal with, and perhaps the Law Society at some point should set aside some time to have a seminar that deals with the question of appeals in these sort of procedural matters, because obviously they are terribly important. Perhaps Judge Turner could now come up and deal with the next subject, please.
We have another interesting topic to be dealt with, and we're running pretty well on time, maybe a few minutes behind, but not too badly. The speaker is Mr. Steve McCann. Steve studied law at the University and he was called to the Bar of Ontario in 1977 and is now a counsel in the policy development activity in the Ministry of the Attorney General. We've known Steve for a number of years. And Steve is indeed one of those capable, conscientious, and reliable people whom one always appreciates having on one's team. Can't give the man a higher qualification, and I ask him to bring forward his crystal ball and see what he can forecast for the future. Steve?
Sorry. Okay, the question that I was asked to speak to is, where will the Provincial Court Civil Division be a year from now? And I'm going to try to do that as briefly as I can, although it's rather a large question and we could spend a good deal of time on it. But I think I'd like to start by saying that there's a document in existence which will have a huge effect on the Provincial Court Civil Division and the small claims courts in the course of the next year, and it's one that all of us will want to acquaint ourselves with, and that is the Courts of Justice Act, which has been referred to several times this afternoon, and I think it might be worthwhile for me to very briefly indicate what this is. The Courts of Justice Act, as you may know, was drafted in connection with the revision of the Supreme and County Court rules, which stems from a report by the late Walter Williston and is now the subject of deliberation by a subcommittee under Mr. Justice Morden of the Supreme Court of Ontario. We can put all that on one side for our purposes, but for our purposes it's important to realize that this is a general revision and consolidation of statutes dealing with the courts and with the administration of justice, And in the course of that, it deals with the small claims courts and the provincial court civil division in a major way. And there are a number of points I'd like to make about it very quickly. First of all, before I do that, I should just briefly say where this stands now. It was introduced for first reading by the Attorney General in the last session of the legislature in October of 1983. It was the subject of hearings it had second reading in, I believe, November of '83. It was the subject of hearings by a committee of the legislature very recently in January, and presumably will be reintroduced in the coming session of the legislature, probably enacted and proclaimed at some time thereafter. I doubt before the 1st of January of next year. Now, of course, proclamation of this act will be in connection with the new rules of practice, which I'm sure you'll be attending programs similar to this one on. Again, we can leave that aside for our purposes and focus on the effect on the small claims courts and the provincial court civil division. The first thing to note is that the bill repeals the Small Claims Courts Act entirely, and it repeals the Provincial Court Civil Division Act entirely. So those are both gone, and they're resurrected in the form of a part of the Courts of Justice Act that constitutes something called the Provincial Court Civil Division. And on pages 233 to 237, I've extracted the parts of the Courts of Justice Act that, in fact, deal with something called the Provincial Court Civil Division. Now, perhaps the first point to note is the name of the court, and I'll just very briefly read Section 78, because I think it's a key one and worth being acquainted with. Subsection 1 of 78 says, "The small claims courts and the Provincial Court Civil Division are amalgamated and continued as a single court of record named the Provincial Court Civil Division and may also be known as the Small Claims Court." So the idea of this is there's one court that covers the whole province of Ontario. It's called the Provincial Court Civil Division, but you can also call it the Small Claims Court. But the key thing is there's one court in future. It does, however, retain the distinction between the monetary jurisdiction of $3,000 and $1,000. Okay, that was something that, as we've heard previously, was added to the Provincial Court Civil Division Act, namely this power to extend the $3,000 jurisdiction by regulation. That's continued in the Courts of Justice Act, so that you could have $3,000 jurisdiction in metropolitan Toronto, $1,000 jurisdiction everywhere else, provision to extend by regulation, but the key thing there is you would at least have the same set of rules and the same set of statutory provisions covering the whole province. So you wouldn't have this difficulty of having to leap from the small claims courts to the Provincial Court Civil Division all the time that has been the subject of comment this morning. Now, there are a couple of other points I want to make. The first one is that if you look at this, it's very short. If this is what replaces all of the Small Claims Courts Act, you wonder what happened to everything that's in the Small Claims Courts Act. What's here is just a skeleton. It deals with certain substantive issues that have to be dealt with by statute. The monetary jurisdiction, the relaxation of the rules of evidence, a few other substantive matters. It also, by the way, Section 83 deals with the right of appeal. Now, I could muddy the waters by reading it and commenting on how it relates to the problems that Mr. Justice Krever was setting out. In view of the time, I don't think I'll do that. But whether it clarifies or muddies matters, at least it's one rule for the whole of the province, which is an improvement. Now, the other major thing is Section 85 of the Courts of Justice Act. First of all, constitutes a rules committee for the Provincial Court Civil Division. Now, bear in mind once again that this means Provincial Court Civil Division of the entire province. Okay, now I think this is a major step forward. Every other court has a rules committee which consists of a representative selection of judges and lawyers and clerks. And our court will have one too in future. And all of those details of practice and procedure which are currently found in the Small Claims Courts Act or by a very cumbersome system of cross-referencing in the Provincial Court Civil Division rules will be open to the Rules Committee to make and to alter as they see fit. So it won't be necessary to go back to the legislature each time there's a minor change in the practice of the small claims courts. You know, even when you want to change a minor detail of service in the past in the small claims court, you have to get legislation. This adds, you know, greatly to delay and so forth. It makes things rather inflexible. In future, this won't be the case. There will be a rules committee, and they'll have full power over all those details of practice and procedure which we've been hearing about today. Now, obviously, the practice and procedure, unless I'm very wrong, will be very similar to what already exists, since much of it is tried and true, but there will be the possibility of changing the rules rather rapidly, and in general it will be more the way the rules proceed in the county court and the Supreme Court. So those are very important changes. The Rules Committee has not yet been appointed, but I expect that will happen in the near future, and they'll have to come to grips with making the rules. So at least from if you like, a textual point of view, what you have to know what the rules of the Provincial Court Civil Division are, things will be a lot simpler in the future. You'll need the Courts of Justice Act and the rules, and that's it. One other point I'd like to make about the Courts of Justice Act, and I didn't unfortunately include this material in the extract, but it is important for you to look at, not just again for the Small Claims Court, but for the County and Supreme Court as well. And that is Part 8 of the Courts of Justice Act. Is entitled Court Proceedings, and it starts out by saying this part applies to civil proceedings in courts of Ontario. That includes the Provincial Court Civil Division. And therefore, everything in Part 8, and it's a lot, unless it's otherwise provided in there, deals with the applies to the Provincial Court Civil Division as well as to all other courts. Now, you've got a whole range of things in there. Courts administering all the rules of law and equity. You've got the power to award costs. You've got pre-judgment and post-judgment interest. You've got power to consolidate proceedings. You've got a lot of very basic procedural law. It's the same law that will apply in the small claims courts as will apply in the higher courts. So once again, I think there's a consolidation of this material which will be very helpful in future. It won't be all over the place. It's in one place. But you do very well to acquaint yourself with the Courts of Justice Act, I think. I didn't have enough copies to bring today, but it's available from the government bookstore, and it's also available from the Ministry of the Attorney General. And I recommend it to you. So those changes are major in terms of the statutory and regulatory format of the Provincial Court Civil Division. As I say, I don't think the procedure is likely to change all that much. I think some problem areas have been identified today which need to be addressed, but I think the basic procedure will remain somewhat similar. However, the documents where you find it will be simpler. There are a couple of other questions that I wanted to address, though, where things are not so simple and optimistic. The first question is the question of expansion of the $3,000 jurisdiction to the rest of the province. And I've already outlined that there were amendments to the Provincial Court Civil Division Act which gave the power to do that by regulation. They've been continued in the Courts of Justice Act. And the question is, when and where will the court be extended? This is one that puts the Ministry of the Attorney General rather in a bind, to speak quite frankly. There's no really simple way of extending the court. The basic constraint, as I think you can appreciate, is resources. To extend the $3,000 jurisdiction to the whole province and do so with a bench of full-time provincial judges who heard all the claims between $1,000 and $3,000, same system that's in place in Toronto, would require at least a doubling of the bench and probably more. So we'd have to appoint 12 to 15 full-time provincial judges. I just don't think that the government is interested in doing that at the moment, and particularly in the current climate of constraint and lack of funding and so on. So unfortunately, that's obviously the best solution and the way things ought to go, but I think that's just a non-starter as an immediate or even short-term solution. The other two options, and these are kind of looming heavy on the horizon, I think, for the Ministry of the Attorney General at the moment, although no concrete decisions have been made on them. One would be to expand on a selective basis, to pick those areas where the $3,000 jurisdiction can be brought into force and do it. And you would have either a county judge or a full-time provincially appointed judge hearing the $1,000 to $3,000 cases. That's a feasible way of proceeding. The great disadvantage of it, of course, is that it continues this split of some areas of the province having a $3,000 jurisdiction, some areas having a $1,000 jurisdiction, which is not very attractive in some ways. The other option that's been suggested is that the $3,000 jurisdiction could be extended to the whole province, and in those areas where you didn't have a full-time provincial judge or a county judge couldn't hear the $1,000 to $3,000, you would change the policy about deputy judges and you would allow deputy judges to hear matters up to $3,000. Now that would be a major change in policy because, as I think you know, in the Provincial Court Civil Division it was decided that $1,000 to $3,000 claims should only be heard by full-time judges. However, necessity is the mother of invention, and perhaps this is the only way that the project can be extended to all of the rest of the province. Now, I don't know which of those options is the one that will be chosen. It has to be chosen pretty soon. Certainly any input that any of you would like to make to the ministry would be most welcome, because it really is a difficult issue and not one that we have any very convincing solution to at the moment, I think. There's one other question which was raised. I think I'll keep my comments on it very short, and that is there likely to be any increase from the $3,000 figure, say, to $5,000 in the near future, even if it were only in metropolitan Toronto? I think the answer to that is, and I've discussed the reasons in my paper, it's very